Good morning, everybody. My name's Nick DiMarco, and I'm going to be chairing along with Mr. Hendel and Mr. McAuliffe, who are the tribunal today. Can I just ask, first of all, whether you have agreed between the teams about who's going first, order, times, and so on?
Good day, Mr. Presiding Arbitrator, esteemed colleagues. We have agreed on the allocation of time, and the appellant will use 11 minutes for procedure and 9 minutes for the merits, and this to be used with 30 seconds for rebuttal and surrebuttal, and respondent will use 10 seconds each for procedure and the merits, and then 30 seconds for rebuttal and surrebuttal on both stages, procedure and the merits. But we could not agree on the order of our submissions. It is our understanding that as the jurisdiction of the tribunal is objective, respondent should start first on the procedure and to be followed by appellant. But respondent has other views, and maybe we can explain here.
Okay, yeah, respondent.
Thank you very much. Good morning, Mr. DiMarco. Firstly, just to clarify, I think Aleksandre mixed things up a bit. We as respondent will need 11 minutes for procedure and 9 minutes on merits. I think the appellant has located 10 minutes. Regarding the structure, we do think it makes a lot of sense that we go first on jurisdiction since we object to jurisdiction. However, on all other procedural issues, we don't really see how we can logically go first, because naturally we need to know what the objections of the appellants are and why they object in regards to the composition of the panel, as well as the evidence. So there we don't really see how it would make sense for us to go first. So we propose that we look at the jurisdiction as a preliminary matter, which we are glad to address first, but on all other procedural issues, we believe it makes a lot more sense if the appellant goes first so that we can respond to any objections.
Do you want to come back on that, appellant?
Yes, Mr. Presiding Arbitrator. It is our understanding that if we are following the substance-wise, then appellant should start first on the challenges, then to be followed by jurisdiction on the respondent, and then appellant on the evidence. And this breaking up of the speeches introduces complexity into the proceedings. Therefore, we believe that respondent knows all our arguments on the challenges, as we have inserted them in the skeleton of arguments. We, on the other hand, we do not know any argument that is going to be voiced with regard to the jurisdiction. Therefore, we believe that respondent should start first on the procedure, finish the procedure, and then to be followed by appellant.
Thank you. Well, I'm grateful for you giving us this problem. It's not what I had in the last round. I'm not entirely sure how I can confer with my wing member arbitrators.
We'll send you all to the breakout room.
All right, but just before you do, Ms. Yalis, before you do either Mr. Hendel or Mr. McAuliffe have any questions they want to raise?
No, at this time, no.
No. Okay, well, we've heard what you said. We'll run away into a breakout room and come back in a moment. Thank you.
I will bring everyone back.
Do we have everyone?
Yes.
Okay, thank you. Okay, well, we have conferred, and whilst we can see the logic in the respondent going first in terms of objecting on jurisdiction, for two reasons, we're not going to do it that way. The first is that this is a moot exercise and we're going to hear everybody anyway. So even if we were persuaded by the respondent, we wouldn't be throwing the case out halfway through, because that wouldn't be fair to the other contestants. And the second is we do have everybody's skeleton arguments. So in that sense, each party ought to know the basis of each other's positions in broad terms. So we're going to hear the appellant first on both issues and the respondent second on both issues. The only remaining question for you then is whether you want the appellant to do the whole thing first. So that is the team procedure followed by merits, and then the other team, or whether you want to do procedure, appellant, respondent, do procedure, and then merits, appellant, and respondent. And that's entirely up to you. So do you have any view on that? Appellant first.
Mr. Presiding Arbitrator, we prefer to start on the procedure and to be followed by respondent on the procedure. And then appellant.
Do you have any view on that?
Yeah, that is fine for us. We're flexible. Okay,
well, we'll do it that way. It's appellant 10 minutes, 10 minutes, respondent 11 minutes, 9 minutes, as I wrote down. And the 30-second each rebuttal, I'm assuming it's the member of the team who's done the procedure, who has, etc. Okay. Now, one further point is that we obviously may have questions for you. We've decided we're not going to interrupt your 10-minute or 11-minute flow, or whatever it is, but wait until you've finished and we shall then ask any questions we have when the stopwatch is off. And we'll do that at the end of each panelist's, or rather each competitor's delivery of their submission. So just to warn you on that, and so you're aware of it. So appellant first on procedure then, please.
Thank you. Members of the tribunal. This case is about selective justice, rather injustice exercised by FIFA. Let us explain what we mean. 107 delegates voted for Bigland in the World Cup elections. One of them was Mr. Adam. FIFA has charged only Mr. Adam with allegations that he sold his vote. FIFA's decision is arbitrary, is based on assumptions without any credible evidence. We therefore seek justice from the CAS Tribunal. As a first point of our submission, we will demonstrate that the CAS has jurisdiction on the case. As a second point, we are obliged to challenge Mr. Andrewax and Ms. Sarah Umaima with all due respect. And finally, we will establish that the evidence submitted by respondent is inadmissible. Starting with the jurisdiction of the CAS derives from Article 58 of the FIFA Statutes and Article 82 of the FIFA Code of Ethics, in conjunction with Rule 47 of the CAS Code of Sports-Related Arbitration. Now, respondent might argue that appellant was late in filing the appeal to the CAS. However, this is the question of the admissibility and not the jurisdiction. And in any way, this objection would be contrary to good faith. Members of the panel, FIFA Appeal Committee admitted the appeal, then considered it on merits and decided the issue, and expressly stated and instructed Mr. Atom to appeal the decision to the CAS. Therefore, FIFA itself instructed Mr. Atom to go to the CAS, and it would be inconsistent behavior to object to the jurisdiction of the tribunal. Thus, the tribunal has jurisdiction on the case. As regards the challenges, we will formalize the challenge with ICAS. However, before that, we would like to share with you the reasons why the challenges are brought. Now, to start with the challenge of Mr. Andre Wax, we brought the challenge as soon as we learned, which was 3 days prior to this hearing. We could not have been aware of the comment earlier, and respondent might invoke the Sunian case. And in the Sunian case, it was decided that the duty of curiosity may extend to social networks only in exceptional cases, when there are circumstances which indicate that there could be possible conflicts of interest. And even then, when there are some circumstances, the requirements for the duty of curiosity are met when we face the ground for and problems for identifying the ground for the challenge. And similarly, in this case, we also face the problems with identifying the ground for the challenge. This is because Mr. Wax has a LinkedIn profile which is far from being official. Mr. Wax uses picture of Aragorn, who is the main character in the Lord of the Rings. And one could not reasonably expect that the comment made by that account on LinkedIn could have been anyhow attributed to Mr. Wax, who is present before us. Therefore, the appeal is admissible, and the tribunal should hear the challenge on its substance. Now, moving to the substance, we state that the challenge should be upheld because of the comment. Now, members of the panel, let's put ourselves in the shoes of Mr. Atom, who is internationally known for his calls against vaccination, and let us put the comment of Mr. Wax together, which is found on page 27, that is Exhibit 7 of the case file. If the tribunal is with me, I'll start discussing the comment. Now, Mr. Wax starts by agreeing with his wife that anti-vaxxers' ignorance kills people. Then he goes on and states, I quote, "To put it plainly, these are uneducated people who think only about themselves," end of quote. Mr. Wax further uses words such as egotistic and free rider. The comment clearly demonstrates personal hostility and prejudice, which Mr. Wax has towards all people who oppose vaccination. Respondent may argue that this comment is not directed to appellant. If not Mr. Atom, who is the addressee of this comment? He is the face of anti-vaccination movement internationally. Even if at the time when the comment was made, Mr. Wax did not assign a specific name to it. Presently, we have the name before the panel, that is Mr. Oliver Atom. In light of all the above, and looking from objective point of view, all reasonable third party will be sure that Mr. Wax does not have that impartiality to adjudicate with free mind. Appellant also challenges Ms. Sarah Omaima with all due respect. There are several factors which justify the challenge. Now, Ms. Omaima was involved in 4 arbitration proceedings to which FIFA was a party. She did not disclose this at the time when accepting the appointment. And respondent might argue that repeat appointments need not be disclosed in sports arbitration. The question is, why has Ms. Omaima disclosed it now? It is apparent that she had some doubts, and eventually, after 3 months of hesitation, she considered it necessary to disclose. Even more alarming is that, despite our request, Ms. Omaima has not specified in how many cases she has been appointed by FIFA. It is this non-transparency that raises legitimate questions and results in lack of confidence in Ms. Omaima. Now, we think the tribunal should look at the picture as a whole, and previous appointments, failure to timely and fully disclose, coupled with failure to cooperate, and now recruitment of FIFA's legal team member taken together, justifies the challenge. In the interest of time, I shall now move to my last submission, that is evidence submitted by respondent is inadmissible. Now, starting with a witness statement, which respondent might try to frame as a documentary evidence. We understand that this is to find the way out of our essential right to cross-examine the witness. Let it be as it may. Respondent wants the tribunal to rely on half-redacted evidence of somebody whose identity is not known by a single soul in this room. We do not know who and how credible the person is. It was decided by the Swiss Federal Tribunal in 2006 that anonymous witness statement can be admissible when the personal safety of the witness is at stake. It was further held in Contador case that abstract danger to the personal safety is not sufficient. Now, we only have whistleblower's assumption that he fears that football fans, and not Mr. Atom himself, but football fans may want to retaliate. This cannot be sufficient when on the other side of the scale, it is my client's constitutional right to fair trial. Besides this, there is no logical explanation why the case itself cannot check the identity and reputation of the witness. Also, the evidence has been admitted in Hardlandian proceedings. It is no assurance that it has credibility. First, Hardland is not a party to the European Convention on Human Rights, and respondent has not demonstrated anyhow how the right to fair trial and its standard is respected. Therefore, all the above leads to inadmissibility of this evidence. Turning to the illegally obtained telegram conversation, such evidence can be admissible under Article 152 of the Swiss Civil Procedural Code only in exceptional circumstances when there is overriding interest. We all agree that fighting the corruption is an important interest. What we submit is that if and when illegally obtained evidence is admitted, this must be done by using the evidence that has higher reliability, that is authentic, and is worth the risk. For instance, in Adamo and Fusimalohi cases, which respondent might rely on, and where illegally obtained evidence was admitted, such evidence had high credibility. In fact, its authenticity was not at all disputed. In the present case, we challenge the authenticity of the telegram conversation, and there are several factors that raise the questions. First, our client is denying that conversation ever took place. Second, these messages are undated. And third, the telegram uses the same algorithm for every message to show the time of delivery. Now, I would like to refer the tribunal to page 13 of the case file and respectfully request time extension for 13 seconds, as I think my time has almost expired.
Yeah, I'm going to cut you off now. It may be that we deal with those matters in questioning, but as you've seen, you've had your 10 minutes. So thank you very much for that. And I'm going to ask my wing members, first of all, Mr. Hendel, if you have any questions.
I do have one. Counsel, you mentioned that your client had a constitutional right to a fair trial, and then you mentioned somewhat in passing the European Convention on Human Rights, and in the context of Hardland not being a party to that convention. Could you clarify what constitution did you refer to, and if you were referring to the European Convention on Human Rights, what specifically does that convention tell us in connection with the admissibility of this evidence?
Mr. Arbitrator, when I referred to the Constitution, it was meant the Swiss Constitution, which is Swiss federal law, is lex arbitri in the case. As regards the European Convention, under Article 6 of the European Convention, the right to fair trial is respected, and this also involves right to cross-examine the witness.
Thank you.
Thank you.
Thank you. Mr. McAuliffe, do you have any questions?
Thank you, Chairman. I have one question to the appellant, and it concerns the challenge against Mr. Vax. And given that at the time of his appointment as president of this panel, it was clearly visible on the CV. There was no disguise of the fact that he was the president of the NGO for the Association for Eradicating Diseases. And if your contention is that your client is the figurehead of the internationally of the anti-vaccination movement, a two-part question. Do you think that for Mr. Atom or his experienced counsel advising him, that should have triggered, firstly, a curiosity about whether or not there was some conflict there? And secondly, if we assume that it would trigger curiosity, where would be the appropriate searches to be made? What search should a dutiful lawyer take in that respect? Thank you.
Thank you, Mr. Arbitrator. First question first. What we submit is that the substance of the challenge is not the difference of opinion which Mr. Wax has following his role as a president of his organization. We submit that the wording of the comment and the way he expresses his opinion is offensive and serves as a ground for the challenge. Now, with respect to the second question, even if appellant were required to did some research, at first it would have been Google, then CAS website, and if Mr. Wax is a part of any law firm, which is not given there, then the website of the law firm. However, in no way could appellant have been reasonably required to check Facebook, Twitter, LinkedIn. It is not the standard for the duty of curiosity, as it is minimized with respect to social networks. Thank you.
Thank you. Just one short question from me. In terms of the jurisdiction point, you spoke about the fact that FIFA itself had said that the appellant could appeal to CAS. Does that, what do you say is the legal effect of that? Or is there one?
Indeed, Mr. Arbitrator, this could be viewed as an offer to arbitrate, which appellant then accepted by filing an appeal to the CAS. It is our position that this serves well for arbitration agreement to be concluded between the parties.
I see. Okay, thank you very much. Okay, so we're now going to hear from the respondent on procedure.
Thank you very much, Mr. President. Just before I start, my name is Luisa Bernasconi. I am counsel for the respondent, FIFA. My co-counsel is Jascha Trubowitz. In the following, I will address the procedural issues of this case, namely the jurisdiction of CAS, composition of the tribunal, as well as the admissibility of evidence. As a first issue, we would like to discuss the issue of CAS jurisdiction. According to Article 82, paragraph 1 of the FIFA Code of Ethics, which in the following I will refer to as FCE, all decisions of the adjudicatory chamber, except for decisions of violations in Article 29 FCE, are final and can only be appealed to CAS. Therefore, if the appellant had intended to challenge the sanction for bribery, he would have had to appeal the adjudicatory chamber's decision, not to the FIFA Appeals Committee, but directly to CAS. He did not do this in time, but in fact, he did not do this at all. Therefore, the decision of the adjudicatory chamber is today final and binding. In contrast, the appeal decision before us was taken by an instance that was not competent to do so and is therefore not a final decision in the meaning of Article 57 of the FIFA statutes and R47 of the CAS Code. Now, the appellant tried to convince the panel that he was entitled to rely on the competence of the appeals committee in good faith. However, the appellant cannot rely on good faith. According to the jurisprudence of the Swiss Federal Tribunal and of the CAS, for example, in the case of Cagliari Calcio versus Olimpia Deportivo, a party cannot rely on good faith if a simple consultation of the applicable regulations would have shown the proper procedural course. This is especially the case if a party, like the appellant, is assisted by legal counsel. In the present case, Article 82, paragraph 1 FCE is crystal clear. It shows what procedural action the appellant should have taken, but which he failed to do. Therefore, we maintain that CAS does not have jurisdiction to hear this case. I will now address the appellant's challenge against Mr. Wax and then the challenge against Professor Umaima. Dear panel, The appellant's challenge of the presiding arbitrator must be dismissed. According to Article R34 of the CAS Code, challenges have to be brought within 7 days after the ground of the challenge was or should have become known. As you can see in Exhibit 7, the basis for the appellant's challenge is a LinkedIn comment published by Mr. Vax on 20 November 2021. Only 3 days ago, after waiting almost 4 months after Mr. Vax made this comment, the appellant decided to raise this issue. It is therefore out of question that the appellant is not in compliance with the 7-day time limit. Dear panel, in the case before us, there is no justification for such a belated challenge. The Swiss Lex Arbitri, namely Article 180, paragraph 2 of the Swiss Private International Law Act, imposes a duty of curiosity on the parties. This requires the parties to investigate potential circumstances that may impair the impartiality or the independence of the arbitrator. What does this mean in practical terms? As the Swiss Federal Tribunal held in the Sun Yang case, it means that the parties have to consult all sources that are likely to provide elements revealing a possible risk of bias. Dear panel, LinkedIn is exactly such a source. It is a social network which specifically serves a purpose of publicly sharing a person's current and previous professional activity. Hence, with all due respect, if the appellant did not look at the arbitrator's LinkedIn profiles, the appellant quite simply failed to carry out the most basic due diligence. Now, the appellant also questions whether the LinkedIn profile is actually that of Mr. Vax. By doing so, the appellant quite simply ignores the facts of this case. Paragraph 12 of the facts of the case clearly states that this comment was published by Mr. Vax. This fact can therefore not be questioned. In any event, the facts do not meet the threshold for challenging an arbitrator. I refer you again to Exhibit 7. What does Mr. Vax actually say here? Mr. Vax's comment simply reflects a statement of public health officials. Additionally, the comment is highly generalized and no personal animus is shown to the appellant. The only conclusion to be taken from the comment is that these two individuals have two different opinions regarding this specific topic, which has nothing to do with the dispute at hand. Esteemed members of the panel, should this fact alone exclude the presiding arbitrator from acting on this panel? No, it should not. I have now explained to the panel why the appellant's challenge of Mr. Vax is not only belated, but also unjustified and must therefore be dismissed. I will now address the appellant's challenge against Professor Umaima. As can be seen in Exhibit 8, Professor Umaima has previously been nominated in a maximum of 2 proceedings by FIFA. This is not sufficient to disqualify her, since this is very common in the field of sports arbitration. As mentioned in footnote 5 of Article 3.1.3 of the IBA Guidelines on Conflict of Interest, it is custom and practice in the field of sports law for parties to appoint the same arbitrator in several cases, and that therefore no disclosure of this fact is required. Even more so, we appreciate that Ms. Umaima shared this fact despite not being obliged to do so. Professor Umaima's business relationship with a former employee of FIFA is not problematic either in this context. The employee has no additional financial or social ties to FIFA and was at no point involved in the proceedings regarding the case before us, neither as an employee of FIFA nor as an employee of Professor Umaima's firm. Additionally, Ms. Umaima disclosed this business affiliation immediately, fulfilling the disclosure requirements stated in Article 3.4.2 of the IBA Guidelines. Lastly, the appellant questions why Professor Umaima did not disclose the outcome of the proceedings in which she acted as an arbitrator. Now, according to Article R43 of the CAS Code, procedures before the CAS are confidential. Therefore, not only did Professor Umaima not have any possibility to disclose such information, she actually did not even have the right to do this. This shows that Professor Umaima strictly observes the framework of the CAS Code, which only corroborates her personality and her high qualifications to sit as an arbitrator in this case. The appellant's challenge against Ms. Umaima is therefore unfounded. Now, before entering into the details of this case, I want to remind the panel what this case is actually about. The appellant is the most important custodian of football in Thailand, being the president of the Football Federation, and should be held to the highest standards. The appellant has betrayed football by getting involved in a bribery scheme to rig the 2026 World Cup election. This momentous decision has distorted the election and cannot remain without consequences if we want to preserve the integrity of the beautiful game of football. Dear panel, we will now go into the details of this case, beginning with the very important evidentiary issues. To mirror the appellant structure, I will first address the so-called witness statement and then the telegram messages. The first piece of evidence contested by the appellant is the statement from the Hardlandian criminal proceedings, and I here refer the panel to Exhibit 4. Esteemed members of the panel, the appellant spent a lot of time talking about why the whistleblower should not be allowed as an anonymous witness in this case. However, this completely misses the point, since the whistleblower quite simply is not a witness in these proceedings. There cannot be a violation of the right to cross-examination if there is no witness to cross-examine. Having said that, the CAS has held, for example, in paragraph 92 of the award of Ricardo Terra Teixeira versus FIFA, that written testimonies are admissible evidence. In such a case, a testimony is simply not regarded as a witness statement, but is admitted as documentary evidence. In paragraph 99 of the same decision, the CAS even confirmed that testimonies from criminal proceedings can be attributed significant evidentiary weight. The basis for this conclusion was the fact that the witnesses had been subject to an inquisitive examination and that their testimony had led to a conviction beyond reasonable doubt. The exact same thing is true in this case. The whistleblower was examined by the Hardlandian judge, and his testimony led to the conviction of 5 football officials beyond reasonable doubt. Hence, CAS jurisprudence shows us 2 things. Firstly, it shows us that the statement contained in Exhibit 4 is fully admissible, and secondly, it shows us that this statement has significant evidentiary value. I will now turn to the second piece of evidence contested by the appellant, namely the telegram messages, and here refer the panel to Exhibit 5. Now, the appellant relies on Article 152 of the Swiss Code on Civil Procedure. This is, however, not applicable since the regulations of procedure lie within the autonomy of the parties, and statutory rules can only be applied per analogy if the parties did not agree themselves on procedural rules. In this case, the admissibility of evidence is regulated in Article 46 of the FIFA Code of Ethics. The provision states that generally, all evidence is admissible unless it has been obtained by means or ways involving violations of human dignity or obviously does not serve to establish relevant facts. The admission of the telegram messages in these proceedings does not constitute a violation of human dignity, as this is only reserved for the most appalling infringements of humanity per se. Consequently, in application of Article 46 FTE, the telegram messages are admissible. This result is underlined by previous CAS jurisprudence on the issue of illegally obtained evidence, and I here refer the panel to the decision of Manchester City FC versus UEFA, in which the CAS admitted hacked emails as evidence, in which the CAS stated that the public interest to uncover the truth generally prevails over opposing personal interest. Lastly, the appellant raises the issue of the authenticity of the telegram messages. I here want to remind the panel that the appellant bears the burden of proof when claiming the falsification of a document. The CAS held in the case of Ricardo Terra Teixeira versus FIFA, and I quote, "The onus of proof remains on FIFA, but the evidential burden of contesting the facts submitted by FIFA and deducing evidence shifts to the appellant." As was shown in the Manchester City FC versus UEFA case, the only way to fulfill this burden is for the appellant to share with the tribunal the real content of his telegram messages. If the appellant is unwilling to do this, he does not meet his burden of proof. I hereby conclude my submissions on the procedural issues, and I'm open to questions if there are any.
Thank you very much. Yes, so questions. Mr. McAuliffe first, do you have any questions?
Yes, I have one short question just on the jurisdiction point that you made, counsel. So let's say, hypothetically, the FIFA Appeals Committee, which the chairman of which had heard the appeal of Mr. Atom, if in those proceedings the FIFA Appeals Committee upheld the appeal, what would be the legal consequence for Mr. Atom, given your legal position regarding the lack of jurisdiction?
So to understand clearly, so your question is, what would be the situation if the Appeals Committee had decided contrary to what it has?
Atom, yes.
Well, I believe that still would not have any effect, because after all, this is a decision rendered by a body that was not competent to render this decision. So I feel in any case, such a decision would not have any effect whatsoever.
Do you think that in that situation, it would be incumbent upon FIFA to appeal that decision to CAS itself, or you would not have to take any further procedural act?
As stated, the appeals committee here is not competent to hear any appeals on violations of Article 27 FCE. So if FIFA, on their part, would have wanted to appeal a decision, we would have appealed the adjudicatory chamber's decision, which was competent, which is the final decision of the competent body.
Thank you. Mr. Hendel.
Yes, I too have a short question for counsel. This involves the challenge, the substance of the challenge to Mr. Vax.
Yes.
I think you said that the facts did not meet the threshold to show impartiality or bias, but I'm not sure if I heard you address the question of the appearance of impartiality or bias. If you didn't, is that an important issue to take into account as well? And can you explain why that threshold is not met in this case either?
Well, maybe just to clarify, we are aware that the threshold for a challenge is met if there is an appearance of bias. So we are very aware of this. However, we do not believe that this is the case in the case before us. As stated, I mean, these are just two people that have two different opinions regarding a topic that has nothing at all to do with the case before us. And I mean, if we were to go that far, to assume that whenever an arbitrator has a different opinion on any subject from one of the parties, then we would soon run out of arbitrators, to be honest.
That prompts me to ask if you know how many arbitrators are on the CAS list from which the president could have been chosen, apart from Mr. Vax.
I think it should be 300 arbitrators on the CAS.
Yes, it might even be 400, but there are hundreds of candidates who could have been chosen to preside this panel who had not expressed an opinion, which may be a very valid opinion, expressed in a very discreet way, as you've described, but on a very sensitive issue, which it happens, the appellant has a very different opinion expressed publicly. And my question essentially was whether, from the perspective of the CAS itself, the appearance or the possible appearance of impartiality might have been better avoided by choosing one of the other arbitrators on the long list that they maintain rather than Mr. Vax.
Well, I mean, I think there's certainly a good question, but let's look at how the CAS chooses the presidents of a panel. They choose the president that is best suited. They choose the best people. They want the best arbitrator. And that, in this case, is Mr. Vax. And I'm sure the CAS was aware of the circumstances, but as we submit, this simply has nothing to do with the case. And I'm sure the CAS saw this as well and said, no, Mr. Vax is the best arbitrator to preside this panel, and therefore chose Mr. Vax as a president of this panel.
Thank you, counsel.
Thank you. Can I just pick up on that point with you? Because I think what you're saying is it's because the subject matter of the LinkedIn post has nothing to do with the case that there's not an issue. So can I give you a hypothetical just to test where the boundaries might lie?
Yes, of course.
Let's say you have somebody who is very homophobic, for example, and says in a post that you can never take seriously anything a gay person says. And a particular advocate for a party is known and out as a gay person. And so that party says, look, clearly you can't have this chairman chairing this arbitration because of his antipathy. towards gay people. That was, in my hypothetical example, the subject matter of the arbitration is the same as this. It's got nothing to do with gay issues or homophobia. Would you say the same thing in that case? And if not, why not?
Well, I think these are two very different things, because if we look at things like homophobia, or for example, as it was in the Sun Yang case, clear and obvious racism, this shows a personal animus on the side of the arbitrator. On the other hand, here, Mr. Vax just states an objective opinion, no personal animus is shown. This is based on scientific facts. So this has nothing to do with personality or, race or sexuality. This has nothing to do with the person of the appellant specifically. This is just a general statement, an objective statement, and shows no personal animus.
Thank you. Okay, thank you both very much on procedure. We're now going to deal with the merits, and it's the appellant going first.
I'm sorry, if I may just use my time for rebuttal.
You want to do it now? Yes, of course. Sorry, I should have asked. Yes, please take it now. Yes.
Now, to answer Mr. McAuliffe's question, in case appeal committee renders a decision, it would have legal effect and would be subject to appeal before the CAS. And now, to answer Mr. Presiding Arbitrator's question, it is this personal belief that also Mr. Vax has, that Mr. Atom has, that Mr. Vax opposes. And like in the case, it would have been directed to gay person, it is also directed to person who opposes vaccination. Thank you.
Thank you. That was within 30 seconds. And so the appellant also will have their rebuttal. I suppose it is now as well. Yeah, go ahead.
Thank you very much. Just very quickly, I want to reiterate that Mr. Vax's comment simply states what health officials say, what politicians all over the world say, and no personal animus is shown to the appellant. Also, his wording is very different from other cases, as in the Sun Yang case, where the wording was extremely violent and contained racial slurs, which I will not restate here, but this is extremely different from cases in which such opinions were an issue.
Thank you. Good. Okay, so now we have the appellant on merits.
Good day, members of the panel. My name is Tatia Nikvashvili, and I represent Appellant in this case. And today I will demonstrate that FIFA's decision should be annulled because Appellant is innocent of bribery, and at the very least, the case cannot be proven. And should the panel decide otherwise, it is our position that the sanctions shall be reduced because of being grossly disproportionate. As a preliminary matter, we would like to draw the panel's attention to the standard of proof required under Article 48 of the FIFA Code of Ethics, that is the comfortable satisfaction. Now, it has been consistently held in the CAS jurisprudence that to reach the comfortable satisfaction, the panel must bear in mind the seriousness of the allegation. Namely, in Kulubu versus UEFA case, the panel stated that the more serious the allegation and its consequences, the higher certainty, that is the level of proof, is needed for the panel to be comfortably satisfied. Likewise, in Brifa versus UEFA case, which respondent relies upon in the list of authorities, it is expressly stated that, I quote, in case of serious allegations, the adjudicatory body should have a high degree of confidence in the quality of the evidence. In the present case, dear members of the panel, we have only two pieces of evidence that are tendered: illegally obtained undated text messages and statement of an unknown person whose credibility is questionable. With these evidences at hand, the panel cannot reach comfortable satisfaction to accuse Mr. Atom of the most serious charges, that is the bribery. Turning to the charge itself, in order to prove bribery under Article 27 and 49 of FCE, the burden is on FIFA to prove that appellant bound by the FCE accepted undue advantages in exchange for him casting a vote in favor for Bigland. FIFA Appeals Committee relies on 3 items as undue advantages allegedly accepted by Mr. Atom: trip to Big Land, revenues from a friendly match, broadcasting, and watches as gifts. Let us address each of them separately. First, the trip to Big Land. This trip was legitimate. May I take the panel to Exhibit 1 on page 6 of the record? Is the tribunal with me? Thanks. This is the email correspondence of Mr. Atom and Mr. Kaiser, the president of the Football Federation of Big Land. This exhibit in paragraph 3 clearly states that the aim of the trip was to discuss future business opportunities. In the course of the trip, it is undisputed that Mr. Atom was guided by Mr. Kaiser to visits to stadiums and to football teams and the local football teams. It is logical, therefore, that the parties discussed yet another business, that is the possibility of a friendly match between their national football teams. Even if the anonymous witness statement is admitted in this case, the evidence only shows that Mr. Atom was far from any advantage, as he himself offered 50-50 distribution of the revenues from the broadcasting of the match. And lastly, the watch. There is nothing other than the inadmissible witness statement that was given to the best knowledge of this unidentified person who was on a celebration on a busy atmosphere. How credible is that? It is our client's firm stance that the watch was never accepted. Further, we submit that there is no ratio of equivalence, which, according to Hamel versus FIFA case, is a critical element for the breach to qualify as a bribery. For example, in Blatter versus FIFA case, the gift of 200,000 did not qualify as a bribe precisely because FIFA was not able to prove the gift was in exchange for the support in the elections. In the present case, Mr. Atom voted in his free will. It is not disputed that Mr. Kaiser asked Mr. Atom to vote for Big Land in the elections on the very last day of the trip. However, I would like to direct the tribunal's attention to the procedural order. On page 6, question 6. Here, this clarification shows the response of Mr. Atom, who made it crystal clear to Mr. Kaiser that he would think about it after considering all the candidates involved. That attests that Mr. Atom was staying true to his values and did not commit anything contrary to his official duties. Members of the panel, had Mr. Atom wished to gain any advantage, it would only make sense that he made a clear promise to Mr. Kaiser. Therefore, there is no quid pro quo. And after considering all the candidates involved, Mr. Atom, just like 108 other delegates, came to the conclusion that Big Land indeed deserved this vote. Dear panel, respondent tries to single out Appellant and find fault where it is absent. Mr. Atom has honorably served football in Thailand for 10 years, and his integrity is so important to him that when he learned that Mr. Kaiser was charged with bribery in the Heartlandian criminal proceedings, he immediately, on the second day, publicly reimbursed to 20,000 to cut all the ties with him. In conclusion, Appellant submits that Mr. Atom is innocent of bribery, and the case against him cannot be proven to any satisfaction of this panel, and hence FIFA's decision should be annulled. To turn to the second issue, should the panel somehow find itself satisfied with FIFA's decision and charge, Appellant requests the sanction to be reduced and limited to a warning or a reprimand, or at the maximum 5-year ban. As a preliminary matter, we note that CAS has the power to hear the case de novo under Article R57 of the CAS Code, which empowers the panel to amend the sanction. Respondent may argue, based on the restraint power of the CAS regarding this issue and sanction review. However, as decided in the Gaza case, there is no restraint of this power when the sanction is evidently and grossly disproportionate to this offense. And this is the case at hand. When determining the proportionality according to cash jurisprudence, there are several factors considered: the degree of guilt, the previous record of the person, return of the advantage, as well as the consistency of cash practice. Taking into account all these factors, we submit that 15-year ban coupled with a 50,000 fine is clearly disproportionate. To compare, in Amos Adamus' case, the member of the FIFA Executive Committee sold his vote for 400,000. And in that case, when his intent was clearly culpable, he was sanctioned just with a fine of just 3 years, coupled with a fine of 10,000. In the case against head of Mongolian Football Federation, Mr. Brianamech was found guilty of several violations of ethics code, including the voting bribery for 2 times in FIFA elections, and he was charged of just 5 years without any monetary fine. Members of the panel, in our case, it is clear that Appellant was at the most innocently negligent in his actions. As mentioned earlier, he comes with an unblemished reputation and has fully reimbursed the alleged improper advantage. In the light of these mitigating factors, the ban of 15 years, that is 5 times more than in Adamu case and 3 times more than in Mongolian case, is grossly disproportionate, and so is the monetary fine. While FIFA should make clear how it calculated the amount, there is no substantiation for the fine of 50,000, thus it is arbitrary and should be lifted or reduced. In conclusion, the sanction imposed shall be limited to a warning or a reprimand, or at the utmost to a 5-year ban. Hereby, Appellant concludes its submissions. Thank you.
Thank you very much. Mr. Hendel, do you have questions?
I do not.
Thank you. Mr. McAuliffe.
I have one question for counsel. I heard you say that the $20,000 was publicly reimbursed, and I'm just curious to know where, maybe I missed it, but where is this statement on the record that it was done, that this reimbursement was done publicly?
Mr. Arbitrator, I would like to clarify that as this evidence is publicly available and this transaction was made between Mr. Atom and Mr. Kaiser instead of some unidentified individuals, this is a public reimbursement. He could have done so, for example, to allow his wife to transfer this fine outside the stage, for example, but this was publicly made. And this can be found in the record. This is the evidence on page 8 of the record, exhibit number 3.
Okay, and do you think, sorry, a follow-up question, do you think it was incumbent upon Mr. Atom to disclose or inform FIFA at the time when he made this reimbursement of 20,000 to Mr. Kaiser? Do you think he should have, at that time, had he had a duty to inform FIFA about this payment?
Mr. Arbitrator, as there is no obligation of such under the FIFA Code of Ethics, Appellant was not obliged to do so.
Okay, thank you very much.
Thank you. I have a kind of similar question, because I wrote down that you said in relation to the watch, I think you said the watch was never accepted. Do I take it from that it was offered?
Yes, Mr. Arbitrator, it is undisputed that it was offered indeed.
And was there then a duty, do you say, for the offer of the watch, which might be seen as an offer of a bribe, to be reported?
Well, it is our position that the watch was never accepted, and there is no evidence that supports this charge and allegation made by Respondent.
No, I understand that, but if what you're saying is there was an offer of a bribe, but the bribe wasn't accepted, isn't there a duty to report that offer?
If this would have been considered as something that was against the duty of Mr. Atom, he would have done so. This is also an obligation under Article 27.2 to avoid anything that would make it the appearance of bribery. However, in this case, there was nothing that would make it apparent that it was indeed the bribery, because Mr. Atom was not aware of any of this, and he only realized this after the criminal proceedings took place in Hardland.
Okay, thank you. Okay, so we now have the respondent on merits, please. And it's 9 minutes this time.
Indeed, Mr. Presiding Arbitrator. All right. Esteemed members of the panel, it is the respondent's position that the appellant breached Article 27 FCE and that the imposed sanctions are indeed proportionate given the appellant's very serious misconduct. Before going into the details of Article 27 FCE, I will first establish to what degree of conviction the panel has to be satisfied that the ethics breach was committed by the appellant. As stated by the appellant, as per Article 48 FCE, the standard of proof of comfortable satisfaction is applied in FIFA ethics proceedings. Over and over again, cast panels such as in Osiris Guzman versus FIFA, Marco Polo Del Nero versus FIFA, and Ricardo Terra Teixeira versus FIFA have confirmed that in bribery cases, the standard of comfortable satisfaction applies. The appellant has alluded to some sort of sliding scale within the standard of comfortable satisfaction by arguing the seriousness of the allegation. In Emmanuel Briefer versus UEFA, the panel firmly rejected such a sliding scale. We want to stress that irrespective of the seriousness of the allegation, the standard of proof is and remains the one of comfortable satisfaction. This standard is not a flexible one, but a rigid one. In conclusion, the panel only has to be comfortably satisfied as to the bribery charges against the appellant. Now, coming to the heart of the matter. How have the appellant's actions breached Article 27 FC? The offense of bribery requires two critical conditions to be fulfilled. First, the appellant has to have accepted a personal or undue pecuniary other advantage. And second, as a service in return, the appellant has to have executed an official act which falls within his discretion. Dear panel, we will show that Mr. Atom accepted financial advantages from Mr. Kaiser, and in return, Mr. Atom voted for Big Land in the 2026 World Cup election. The starting point of this bribery scheme is Exhibit 1. I refer the panel to this exhibit. It is an email from Mr. Kaiser to Mr. Atom and his business associate, Mr. Lenders. As you can see, Mr. Kaiser invited Mr. Atom to Big Land to discuss alleged business opportunities between the federations of Tiny Land and Big Land. The trip cost being completely free must have piqued Mr. Atom's interest. This gift, including a business class trip to Big Land, as shown in Exhibit 2, turned out to be the very beginning of Mr. Atom's trip of indulgence. What happened next is what the appellant has eagerly tried to suppress in its submission by not going to the details of Exhibits 4 and 5. I referred the panel to Exhibit 4. In pairs 12 and 17, the witness provides a credible observation on the appellant. The appellant's trip turned out to be a lavish, all-inclusive, luxurious stay, topped off with an expensive dinner at the famous Michelin star restaurant Nastimon and a night of clubbing at the most luxurious club in fancy capital. Mr. Kaiser even handed him an expensive watch. Conducting actual business appeared to be the last thing on the appellant's mind. The appellant thus accepted personal financial advantages. What is left to show is that the appellant, in return for these advantages, executed an official act. In other words, as stated in Marco Polo Del Nero versus FIFA, there needs to be a quid pro quo between the advantage and the act. The appellant says there was no quid pro quo. I will show you why this is wrong. I refer the panel to Exhibit 5. This shows the telegram messages between Mr. Atom and Mr. Lenders discussing their crazy nights in Big Land. I would like to draw your attention to the last two messages. Mr. Atom writes, "Yeah, I've thought about it. After all they did for us, the least we can do is vote for them." To this, Mr. Lenders replies, "Yep, agreed. We cannot draw back now." Dear panel, let that sink in. After all they did for us, What does this show us about the appellant's mindset? The appellant is not concerned at all about what is best for the game of football, but solely sees the vote as a quid pro quo for his financial benefits. The phrasing, "we cannot draw back now," shows that the appellant made a commitment to Mr. Kaiser to vote for Bigland in the 2026 World Cup election. This shows an obvious quid pro quo between the advantage and the appellant's conduct. I want to address one more piece of evidence, Exhibit 3. It shows that the appellant wired 20,000 Swiss francs to Mr. Kaiser and not to the Football Federation of Bigland. And I just want to clarify, this seems to be hardly public, as it was not that it was sent directly to Mr. Kaiser. The transfer is dated 8 September 2018, more than 2 years after the appellant's trip to Bigland. What motivated the appellant to make this money transfer on this specific date? A day earlier, a Hardlandian judge had convicted 5 football officials, as well as Mr. Kaiser, of being involved in the bribery scheme to vote for Bigland. That others got caught for bribery must have absolutely terrified the appellant. The rush money transfer shows that the appellant knew that strings were attached to the benefits he received from Mr. Kaiser. The misleading reimbursement can only be regarded as what it is, an admission of guilt. All arguments considered, we ask the members of the tribunal to pay attention to the big picture. If you take every piece of evidence together, it forms a coherent scheme of serious bribery. In conclusion, let's quickly reiterate how the appellant fulfilled Article 27 FC. Mr. Adam accepted financial advantages from Mr. Kaiser, and in return for this, voted for Bigland in the 2026 World Cup election. Dear panel, as a last issue, I will now address the sanctions imposed on the appellant. In the following, I will demonstrate why the sanctions imposed on the appellant are not grossly disproportionate, and why, therefore, this panel must refrain from reviewing this sanction. Cost jurisprudence such as Al-Ittihad Saudi versus FIFA, Osiris Guzman versus FIFA, and Blatter versus FIFA have introduced a high threshold for restraining the discretionary powers of sports bodies. Sanctions should only be reviewed when they are evidently and grossly disproportionate. Contrary to what the appellant is claiming, the imposed 15-year ban and 50,000 Swiss franc fine are not grossly disproportionate. Therefore, this panel must refrain from reviewing this sanction. First, the appellant suggests his long history of service to football and his good record should be a mitigating factor. If anything, this should be considered an aggregating factor, as the panel in Marco Polo del Nero versus FIFA held, experience and seniority meant that the offender had an even greater duty to act within the rules applicable to him. Second, contrary to the appellant's claims, the reimbursement has already been factored in the level of sanctions. Since the fine is below the minimum fine level, in fact, the minimum of sanction of 100,000 Swiss francs as prescribed by Article 27, Para 3 FC has already been reduced by half. Furthermore, the appellant cites a decades-old case of Amos Adamo versus FIFA, which should not be used as a guiding case law. There has been an evolution in the jurisprudence of FIFA since the corruption scandals of Blatter and Platini. Against this backdrop, I will now explain why the appellant's proposed sanctions are inappropriate. In the recent bribery cases of Kwesi Nyantakyi versus FIFA and Ricardo Terra Teixeira versus FIFA, the offenders were given a 15-year, respectively a lifetime ban. Dear panel, you may ask yourself why a 15-year ban in this specific case is justified. The appellant sold his vote to Bigland. This is a grave violation of a democratic process, not just any democratic process, but for the selection of the location of the most prestigious football tournament in the world. A 15-year ban is necessary to deter future football officials from doing the same, to protect the integrity of the game of football and to ensure the public's trust in FIFA's democratic processes. Finally, Article 27, Paragraph 3 of the FC clearly states that persons holding high positions should be sanctioned tougher. With great power comes great responsibility. In summary, the 15-year ban and the 50,000 Swiss franc fine imposed on the appellant are proportionate. To conclude my submission, I want to reiterate the following. The appellant received the financial advantages and in return voted for Bigland. Mr. Atta, one of the custodians of football, thus committed bribery. Such conduct cannot be left without consequences to preserve the integrity of the beautiful game. We therefore ask the panel to dismiss the appeal. Thank you.
Thank you very much. So we're now going to deal with the rebuttal. Oh, I'm sorry. I jumped far too quickly. Questions. I'm sure we've got questions. I had a question. So Mr. McAuliffe first.
Thank you, Council. I noticed, and you've made a reference to it, ORL3, the Adamu case. Now, to my mind, you mentioned it was decades old, but in practical terms, in reality, we are talking here about a vote for the allocation of the 2026 World Cup. And in the Adamu case, it concerned a vote for the 2018 and 2022 World Cup. So the immediately preceding biggest decision that FIFA takes. And in that case, it was a executive committee member. There was a 24 executive committee members who had a vote. Here, it is not there's no longer an executive committee. This is a FIFA council, but the decision is taken by all of the federations. So it was a much higher level official, much more experienced. And you're drawing our attention to paragraph 161 in ORL3, which references 3 years that he got as a ban. So I'm trying to identify, is there any other case which you think that you have enlisted here, which has a closer factual constellation to the current case? And which case are you relying on specifically to justify 15 years as a ban, to make sure that it's proportionate?
All right, so let me elaborate then on this. So first of all, there is jurisprudence with regarding the interference in democratic processes. This would be, for instance, Fernando Fernando versus FIFA. It concerned the interference in the democratic process of electing an individual for the position on the executive committee. The person the individual in that case got a lifetime ban. So there is cost jurisprudence with regards to the interference of democratic processes. Now, especially with regards to the Amos Adamu case, I would like to clarify. First, we want to stress that the panel itself stated in that case that the sanction might even be deemed a relatively mild sanction, given the seriousness of the offense. The panel dismissed the appeal of Amos Adamu to have his ban reduced or even overturned, and therefore did not have the authority to impose a higher sanction. I think this is critical in that decision. The panel itself said this is a mild decision, but the problem was they couldn't change it. Now, FIFA itself explained that there is now an evolution in the way they sanction football officials. Hence, in this case, it is very much proportionate to impose a 15-year ban.
I'm sorry, just my last point. And which specific case are you relying on as your go-to case to identify where a 15-year ban was imposed or higher?
It would be the Manila, it is the Vernon Manila Fernando case, and it concerned rigging the election. Oh, excuse me. Is that right?
Thank you very much.
Thank you. Mr. Hendel.
No questions.
Thank you. I have one question. When you were dealing with comfortable satisfaction, you mentioned a case, I'm sorry, I didn't write it down in time, where you said that the argument that the appellant had put, that the more serious the allegation, the more compelling the evidence has to be. That kind of argument about perhaps a shifting standard was rejected. Can you just take me to the passage in that case, if it's in the bundles before us, where that's said, or otherwise just tell me exactly what's said?
Most certainly. So I shall provide the passage. It is the Manuel Briefer versus UEFA case, case number 5,920 and para 84. And just quickly reiterate, the panel firmly rejected a sliding scale, so that the bearing, let's say, in taking into consideration the seriousness of the allegation, that does not have an influence, that does not affect, that does not show that the standard of proof is a flexible one, but still remains the same as in its comfortable satisfaction.
But it's right, isn't it? I'm sorry, I don't have the passage up before me, so I'm not sure exactly what it says. It's right, isn't it, that although it's still the same standard of proof, where an allegation is more serious and perhaps less likely to have taken place, one's going to expect stronger evidence in order to prove it. That's correct, isn't it?
Indeed, the key consideration is you cannot be less or more comfortably satisfied.
I understand. Thank you.
You're always comfortably satisfied.
Yeah,
and
understood.
our position is that the evidence provided is high quality evidence that would lead the panel to comfortable satisfaction.
Understood. Thank you. Okay, so I think we now move to the rebuttals. Appellant first.
Thank you. Respondent relies on cash jurisprudence regarding sanctions and proportionality. However, unfortunately, the factual circumstances of those cases hugely differ from this case present at hand. And it is stated that the cases that are not similar shall not be shared. For example, in Tatia case, the appellant accepted $2.5 million USD, and in other cases as well, the persons were the masterminds and the driving force of the perjury.
I'm very sorry to interrupt. I'm going to be strict with the 30 seconds. Thank you.
Thank you.
Yes.
I'll still address the case mentioned by the appellant named Kharatisvhili. So that is a completely different case. It relies on completely different facts, and we're not talking about certainly the amount of bribes is something to be considered. But the key issue and what should be given great weight in this case is the deterrent effect of the ban. And we want to make sure and preserve the democratic processes of FIFA, and hence the ban of 15 years.
Again, sorry, going to have to interrupt. Thank you both very much. Thank you all very much. So I think what happens now is we are all going to stop being live streamed and go into breakout rooms. And then we're going to come back and talk to you all and have some feedback. So thank you very much. And we'll speak to you in a moment.